Welcome back to Oil and Gas. Today we're going to talk about terminable interests, which are interests that only last for a term. So whether it's a non-participating royalty interest or a mineral interest, an interest that only lasts for some term of years. So an interest that will or may not be perpetual. Commonly, they might be fixed. We remember this from the Govenda case we talked about earlier, like for 15 years. Sometimes they can be defeasible. So sometimes they say for 15 years and so long thereafter as oil or gas is produced. That can create some special issues that we will look at, including in this Archer County versus Webb case, which is from Texas, 1960, and it's on page 523 of your books. So 30 years previous, 1929, Ferguson got a 1/2 interest in all oil and gas royalty. Okay, so that doesn't have the Govenda problem, right? Where it's just a 1/2 royalty. This says 1/2 of the all oil and gas royalty. So Ferguson was getting a 1/2 interest in all the oil and gas royalty, but it's only for 15 years or so long thereafter as oil and gas shall be produced. Now what happened? 11 years later, Webb, the subsequent owner, leases the land. A gas well is drilled in 1943, still within that 15-year period, and shut-in royalties are paid. But the well doesn't finally produce until there's a market available in 1948. So the question is, did that term interest, that terminable interest, did it expire? Because it went, within 15 years, there was a gas well drilled and shut-in royalties were paid, but there wasn't literal production. There wasn't literal production, paying quantities until the well produces in 1948. Court says because there was no literal production, the term ended. And so Ferguson gets nothing right there. That interest just ended. Okay. The dissent says, well, doesn't the lease define what production is? And doesn't production in the lease, shut-in royalties, count as constructive production? We've talked about them. They extend the lease. They're enough to production for the lease to extend. So shouldn't that term interest be extended as well? Also, this rule that Texas follows, that there has to be literal production to extend that term interest, doesn't that create, some shenanigans here? Because imagine that, Webb had really thought that through, right? He doesn't want to have to give up half of his royalty to the royalty owner. So would he have really leased it in 40 and allowed a well to be drilled in 43? No, he would have told the oil company, don't drill until 15 years after so that I don't have to deal with somebody else owning half of all my royalty. So instead, let's just wait until it's time to drill and we'll get out of, we will not have to pay anything under the lease. So that's the dissent's argument, but ultimately it doesn't carry the day. Texas rule, there's no literal production, that defeasible term ends. Okay. Keep in mind, that kind of makes sense with the Stanley decision. Remember, in Texas, just because you have a well capable of production, that doesn't count as production for the lease unless you have a shut-in royalty clause. That term interest here didn't include a shut-in royalty clause, right? It just said, so long thereafter as oil and gas is produced. And so like in Stanley, you would think that therefore, by the literal terms, the defeasible interest, that term interest ends. But wait a second. Okay, does that suggest the rule will be different in Oklahoma? Because remember, in Oklahoma allows you to shut in a well that's capable of production if you're just waiting for higher prices in that PAC case, that Santa Fe versus PAC case in Oklahoma. So do you think a term interest gets extended in Oklahoma? Well, it turns out not, actually. So Oklahoma follows the same rule as Texas. And the reason is a little bit complex, but basically the idea is, look, we're going to, under a lease in Oklahoma, allow the producer to shut it in for a period of time to wait for higher prices, because both the landowner and the oil and gas company benefit from higher prices, since the landowner receives his or her 1/8 share, or whatever the royalty landowner share is, and the higher prices, the bigger that share is. So they have a cooperative interest. Whereas by contrast, if the oil and gas company doesn't allow production, that doesn't provide a benefit to, it's not in that kind of cooperative relationship with the term interest holder. Because as far as the oil and gas company is concerned, it would just like to cut off that term interest holder's interest and just pay the landowner. So they don't have that kind of cooperative relationship. And so therefore, we're not going to extend that term interest for cooperative reasons. It just ends. So the reality is these term interests, are a little bit dangerous, because the courts basically allow oil and gas companies to just avoid them by just waiting long enough. So that is one big difference between how a lease works and how these term interests work. Okay, so just to give you an example, imagine that Frank Farmer in 1980 conveyed Blackacre to Sally Rancher, but he reserved 1/16. So he didn't do this of business. He had a definite royalty. I just want 1/16 of the oil and gas for 15 years and so long thereafter as oil and gas are produced. 1990, so just 10 years later, Frank leases to Acme Oil Company that primary term of 5 years. So it'll expire just when, and this should actually be Sally. That'll expire just when Frank's reservation will expire. Acme completes, shuts in a well, 1994, just before the primary term ends, just before that terminable interest ends, waiting for higher prices. So what happens to Frank's mineral interest, and what happens to Acme's lease? This is basically the Archer versus Webb case all over again. The Acme's lease is going to be extended if there is a shut-in royalty clause, or if it's in Oklahoma and capable of production is enough to extend the lease. But Frank's mineral interest is going to stop, because you have to have literal production for that terminable interest to extend.